Thank you very much, Madam Chair. Ranking Member Rodgers, let me start out asking you a little bit about the purpose of the legislation. The bill's entitled the Women's Health Protection Act, but nowhere the purpose, does the bill state, does it even mention women or their health? So from your perspective, what's the real purpose of the legislation?
The stated purpose of the bill is to permit abortion providers, quote, to provide abortion services without limitations or requirements that single out the provision of abortion services, and requirements that make abortion services more difficult to access, and, quote, to promote access to abortion services. This legislation is really about a mandate by the federal government that would demand abortions on demand without any considerations for anyone, including the conscience of the providers. It would override state laws.
No, that's not true. That isn't true, though. That's not correct.
Some of the proponents of the legislation describe the bill as simply codifying the Supreme Court decision on Roe versus Wade. Would you agree with that?
I strongly disagree. It goes way beyond Roe v. Wade. Roe versus Wade allowed for state laws, informed consent regulations, ultrasound requirements, parental involvement or notification in the case of minors, aiming to protect women from coercion, such as in-person counseling. This bill would preempt and prevent these common sense laws that are permitted under Roe.
I also want to focus on some of the specific differences. In Roe versus Wade, the Supreme Court found that women have the right to abort a fetus prior to viability without undue interference, and they also found that viability occurs at approximately 28 weeks. How does this legislation before us address the issue of viability?
Well, the definition of viability is whatever the person performing the abortion says that it is.
So it can go beyond 28 weeks.
It's up to the person performing the abortion.
Okay, my friends on the other side often talk a lot about trusting science. Can you talk about some of the advancements in science that have occurred since 1973 when people, frankly, didn't know today what we know about fetal development?
Yes. It's really amazing when you can look and watch the development of a baby week by week. By 10 weeks, an unborn baby has arms, legs, fingers, toes, sucks his or her thumb. The baby will jump if startled. The baby's well on its way to being able to feel pain. By 15 weeks, all of the unborn baby's major organs have developed. And there's a rapidly developing field of medicine to treat prenatally babies in the womb, cure diseases or perform surgeries on an unborn baby, now even at 15 weeks. It's truly remarkable.
I think you touched on this, but just to get it for the record, if someone has a moral objection to performing or assisting in abortion services under current law, they're protected from employment discrimination. Does this legislation before us today preserve those protections?
Well, conscience laws are not specifically called out in the legislation. However, subsection B is so broad that any law that singles out abortion services and, quote, impedes access to abortion could be prohibited. Given section 7 of the law says, quote, courts shall liberally construe such provisions. In my opinion, provider conscience laws would be preempted, and those would impede access to an abortion by the provider. The law also says that a healthcare provider has a statutory right to perform abortion services and may provide abortion services, and that a provider's patient has a corresponding right to receive such services. So the bill is explicitly stating that no one can seek relief under any other provision of federal law, including the Religious Freedom Restoration Act.
Thank you very much. Thank you, Madam Chair. Yield back.
Ranking member yields.